Ready, start. While making any correction in the entries relating to these matters, the requirements of moving the applications within 3 years has to be adhered to, as any correction in regard to these entries would have an impact on the rights of other candidates when they seek admission to higher classes or employment. Full stop. However, the other particulars contained in the certificate, like the name of the candidate or the names of the parents of the candidates, are not relevant, and any correction made in regard to these particulars would have no impact on the admission or employment of other candidates. Full stop. When so considered, we feel persuaded to hold that the time limit of 3 years prescribed in the substantive part of the Regulation 7 for submission of an application for making correction in the certificate issued by the board in regard to the name of the candidates or the names of the parents of candidate should not have been insisted upon, particularly when the board itself considered it appropriate, or the names of the parents of the candidate to have no time limit under the provision for making correction in regard to any spelling mistake in the name of the candidate or his parents. Full stop. The applicant must, however, explain to the board the reason on the basis of which the application could not be submitted earlier, and it is found that the claim is bona fide and is otherwise justified. There is no reason to reject the application, as in the present case, merely on the ground of delay. Full stop. Undoubtedly, the board has to examine whether any genuine ground has been made out for correcting the name, and it will to open to the board to consider all the materials pertaining to the request for correction of the name. Full stop. Para. In the circumstances, we are of the view that the impugnate order of the first respondent rejecting the application submitted by the appellant for correction for the name of his mother in the high school and intermediate examination only on the ground of delay is unsustainable. Full stop. We accordingly direct the first respondent to reconsider the application, having due regard to all the documentary evidence which may be produced by the appellant. Full stop. The first respondent would also be liberty to summon all the relevant records from the concerned institution for the purpose of deciding the application of the appellant. Full stop. We clarify that the interpretation which we have placed in aforesaid terms governs only the mistake in the certificate in the name of the candidate of in the names of his parents. Full stop. The first respondent shall now pass a fresh order in accordance with law within a period of 4 months from the date of receipt of a certified copy of this order. Full stop. In order to facilitate this exercise, the impugnate order dated October 2023, the said aside. Full stop. The order of the learned single judge shall in consequence be set aside and be submitted by the aforesaid directions. Para. The appeal is accordingly allowed to the extent and the indicate of the matter. Full stop.